Hello, and welcome to Chapter 10 in Healthcare Law and Ethics. We are talking about the HIPAA privacy rule. And as you can see on our slide deck and in the book, this is going to be part 1. We're going to cover part 2 when we get to Chapter 11. Now, I'm going to break these sections down into their own lectures just because I think it'll be easier for you to absorb the information that way instead of throwing too much at you at one time. I'm going to try to keep these relatively short and sweet, 15-20 minutes max, especially this first section because it's only 2 slides in our slide deck. So if you follow along with me on page 205, it talks about how April the 14th, 2003 marked the effective date of a law heralded to be some of the most dramatic change to healthcare since the implementation of Medicare and Medicaid. So the healthcare industry ushered in the portion of the Health Insurance Portability and Accountability Act known as the Privacy Rule. Now, the Privacy Rule, the main purpose is consistent with our purpose as health information professionals. We try to protect patient information. Now, when we go along over to 206, it gets into the meat of HIPAA, the Health Insurance Portability and Accountability Act. The first little section up there talks about the main goals of the HIPAA privacy rule. Okay, so we know it's talking about protection of patient information, but our first goal is to protect patient information, and that's going to be done by limiting access to others. And then our second goal is to provide individuals with greater rights to their information. So one hand, we're limiting the access of information to others, but we're broadening the access of information to the individual. Now, in the source of HIPAA, it just kind of gives us background information on where HIPAA started. So HIPAA was enacted by Congress in August of 1996, and it goes into that paragraph talking about how the privacy law or privacy rule actually came into play. So it says in December of 2000, the original published standards for the HIPAA privacy rule was published in the Federal Register, but it wasn't actually finally modified with amendments until August of 2012. And in healthcare, they always try to give you a little leeway. They let you know what's coming down the pipeline so you have time to make your changes. So it was finalized in August of 2002, implemented in April of 2003. And then when we could drop down into that bottom section and move over into page 207 where you see figure 10.1, we get into HIPAA as a whole. Now, HIPAA has 5 major sections or broad sections, and those are called titles. And most of these have nothing to do with patient information. Okay? So the 5 titles address more than the privacy of our patients' information. Title 1 protects individuals and their dependents from losing their health insurance when leaving or changing jobs by continuing to provide insurance continuity. So that's where HIPAA actually started. The whole name in and of itself, Health Insurance Portability. I leave a job and I need to have insurance. I can port that insurance to my new workplace and so on. Now, titles 3, 4, and 5 contain tax-related provisions relevant to the Internal Revenue Code and requirements for group health plans. Now, Title 2 is the most relevant to the management of health information. It contains provisions relating to the prevention of healthcare fraud and abuse, medical liability reform, and administrative simplification. Now, the privacy rule resides in the administrative simplification provision of Title II along with the HIPAA security regulations. Now, that's Chapter 12, which we're not covering in this section. You'll cover that in electronic health records next semester. So, dropping down to that paragraph, it says, because the complexity of HIPAA is well known, the term administrative simplification seems counterintuitive. However, this term refers to HIPAA's attempt to streamline and standardize the healthcare industry's non-uniform and inefficient business practices such as billing. A significant part of this simplification process is the creation of standards for electronic transmission of data. So this was the original intent of HIPAA, and then later on they added the privacy and security rules. Now, dropping down into that next section, we get into the American Recovery and Reinvestment Act of 2009. Now, this was signed into law in February of 2009 by President Obama, and it included significant funding for health information technology and other stimulus funding. Because remember, we had the economic downturn in 2008, which we're now experiencing now again because of coronavirus, and we already hear President Trump talking about some stimulus funding or some bailout money here and there. So that's originally what the American Recovery and Reinvestment Act was a stimulus funding plan. Now, it also provided for significant changes to the HIPAA privacy rule, and these changes were in HITECH, the Health Information Technology for Economic and Clinical Health Act. Now, major revisions, which we're going to address in this chapter, included changes to the requirements related to business associates and their subcontractors, protected health information of deceased individuals, notice of privacy practices, the sale of information, provisions affecting the minimum necessary requirement, individual rights, student immunization records, research authorizations, breach notification, provisions affecting personal health record vendors, marketing and fundraising, and increased enforcement and penalties for noncompliance. And so we're going to get into all of that throughout this chapter. Now, it also talks about how that ARRA also established the Office of National Coordinator for Health Information Technology. Now, partial or practical implications were the creation for HIT Policy Committee to address technologies to promote the electronic health records privacy and security. The establishment of our HIT standards committees consisting with members with expertise in healthcare privacy and security, and the appointment of an ONC Chief Privacy Officer to advise on electronic health information privacy, security, and data stewardship. Now, our second section in our last slide gets into some of these federal laws that were in place prior to the implementation of the HIPAA privacy rule. And it's just going to kind of show us how limited these were in their authority and how they're limited in their application. All right, so legal protection of the privacy of patient information historically resided with individual state laws, creating a complex patchwork effect. Some states broadly address patient confidentiality, where others only protected a specific certain type of records, maybe an HIV record or behavioral health records. And then other states had pretty much no patient confidentiality protections. So our inconsistent state laws provided varying degrees of protection. Dropping down to that paragraph, limited and inconsistent federal and state laws left many types of health information, especially those not deemed to be of a highly sensitive nature, unprotected by any statute. Often the only recourse that individuals had if their confidentiality was breached was through the court system. And we know that that's expensive, time-consuming, emotionally exhausting, and there's no guaranteed outcome. Under the HIPAA privacy rule, all types of health information are treated equally, regardless of their nature. Further, HIPAA violations result in sanctions outside of the judicial system, so we're not depending on a court system to give us results. Overall, the privacy rule is designed to increase privacy and confidentiality of patient information and to provide a less cumbersome recourse. Now, the HIPAA privacy rule transformed the landscape of patient information by expanding the breadth of privacy protection and protecting the confidentiality of a widely defined scope of medical and personal information. So we know HIPAA is the top dog out there. It's a federal law. It covers every state, so everybody's following the same laws now. But prior to that, we did have some rules in place, some laws in place, but again, they weren't very authoritative. They didn't cover everything. So let's look at a few of these. So the Freedom of Information Act of 1967, that's our first one. Now the whole purpose of this one is not the privacy of information, but the right of disclosure to and access by the public regarding federal agency records. So the rationale for such openness is government's accountability to its citizens and ultimately the taxpayers. So this legislation provided exceptions for documents such as medical records to preserve the right of individuals to preserve the privacy of the individuals about whom they're written. Now, one significant exception is the Department of Veteran Affairs through its operation of federal inpatient and outpatient healthcare facilities. So this was a narrow application to the healthcare system because not all healthcare organizations were federal. Now the next one, the Privacy Act of 1974. This was passed to protect privacy. It provides individuals with privacy rights by requiring federal agencies that hold personally identifiable records to safeguard the information. Individuals also have the right to access and request amendments to the records. Now, although the purpose of the legislation is non-disclosure, whereas the Freedom of Information Act was disclosure, this act is also narrow because it only applies to information collected by the federal government. So again, your VA facilities. Okay, then we have federal drug and alcohol laws. Well, again, those are going to be very narrow in scope because they are in place to protect information relating to the diagnosis, treatment, or referral for treatment of conditions relating to drug abuse and other substance abuse. So again, very limited. It's not protecting a general population. It's a very niche population of patients. And then we have the Medicare conditions of participation. So the requirements that govern providers receiving Medicare and Medicaid reimbursement include confidentiality provisions. However, the conditions of participation regulate only providers and narrower still, only those receiving funds from Medicare and Medicaid. So if you don't accept Medicare and Medicaid, then the conditions of participation do not apply to you. So again, some of these are very limited in their scope or limited in their authority. All right, moving over to 210, getting into state laws. So we said earlier that state laws, varied considerably. Some were broad, some were narrow, and some had none at all. But this says, although many states pass laws to protect highly sensitive health records such as behavioral health and HIV and AIDS, not all states possess laws that protected health information generally. So with the passage of the privacy rule, a minimum amount of protection, so that's the bottom, the floor, was achieved uniformly across all states through the establishment of a consistent set of requirements that affected providers, healthcare clearinghouses, and health plans. Now, last but not least, we have professional ethical standards and codes of conduct. So ethical standards and codes of conduct govern a variety of healthcare professionals, including health information management and informatics professionals, and provide guidance regarding privacy protection to patient information. And so, of course, the AHIMA Code of Ethics states that HIM professionals preserve, protect, and secure personal health information in any form or medium, and hold in the highest regards health information and other information in a confidential nature. Now, although the AHIMA Code of Ethics does not have the force of law, because again, it's just a professional organization, it nonetheless provides ethical principles that guide the profession and bind individuals who are members of AHIMA and those that hold an AHIMA credential. Alright, so that covers our first section. So let's look at Check Your Understanding for 10.1. So number 1, drug and alcohol abuse treatment records receive special protection under federal law. That is true. We had the Drug Abuse Prevention, Treatment, and Rehab Act of 1972 and the Comprehensive Alcohol Abuse and Alcoholism Prevention, Treatment, and Rehab Act of 1970. All right, number 2, the privacy rule resides in the administrative simplification provision of Title II of HIPAA. That is true. It resides there along with the security rule, and if you go back to page 207, it also included transactions and code set standardization. It included identifiers, talking about unique national provider identifiers, and then the enforcement rule. So you see security and privacy down there as well in the bottom line of figure 10.1. All right, number 3, the HITECH Act of ARA of 2009 made minimal changes to the HIPAA privacy rule. All right, let's go back and let's take a look at what it says. That would be false. It made significant changes to the HIPAA privacy rule. Okay, that's over on 207 under the ARA section. And then number 4, FOIA was enacted to address the privacy of health information. Okay, so FOIA is Freedom of Information Act. It was not enacted to address the privacy. It was enacted to address the disclosure and the access to information. So that is false. And then number 5, the conditions of participation regulate all providers, including those who receive funds from the Medicare and Medicaid programs. That is false. It does not regulate all providers. It only regulates those that are providers receiving funds from Medicare and Medicaid. So if you do not receive Medicare and Medicaid as a reimbursement method in your facility, then conditions of participation have nothing to do with you. All right, so that's going to end lecture 1 for chapter 10. We'll pick up with section 10.2, and then we'll finish out each one of these individually. So be sure to read through each word of this section. I know I covered a lot of the high points, but it's good to go back and get all of the details. Happy reading and happy studying.